Akinyosoye Arosoyin, Akiyosonye, Arosanyin. Made, is Made here? Right. The last but not the least, Ayodeji Afolabi, Ayodeji Afolabi. BI. My Lord, we are preparing for the prosecution. Thank you, my Lord.
Yes, defendants.
Mazi Nnamdi Kanu, MAZI-NAMDIKNU, appearing pro se.
Thank you.
Thank you, my Lord.
Thank you. Before I delivered the judgments, I think it's just unfair to call the defendants, because after the judgment was reserved, while reading the file, I observed that some processes were filed. Defendants, can you identify these processes and let me know what you want to do with them?
I am most grateful, my Lord. We have joined issues on the motion on notice, my Lord, asking this very honorable court to refer certain substantial constitutional questions arising in this very trial to the Court of Appeal. That's the first one.
Defendant, please.
My Lord.
While you identify your motions, tell us the date on the motion and the date you file same.
Thank you, my Lord. Most respectfully, my Lord, this motion on notice was dated and filed on the 12th day of November 2025. An order, my Lord, praying this very honorable court to refer very, very substantial constitutional questions raised in this very trial to the Court of Appeal. It is a constitutional application, my Lord, firmly anchored on Section 295, Sub 2 of the Constitution of the Federal.
Please identify all the pending motions.
All the pending ones, I will, my Lord.
Identify the one dated on file 12th day of November. Can you identify them one by one?
It is a motion on notice, my Lord, brought pursuant to sections 1 sub 1.
Identify all the motions.
That is exactly what I'm trying to do.
You have identified one.
The next one is a notice of the defendant's commitment to file a final written address. This was filed on the 11th day of November and dated on the 11th day of November 2025. That is the second one, my Lord. Dated 11th day of November 2025 and filed on the 11th day of November 2025, my Lord. Those are the two applications before this very honorable court.
Get me the second one. Dated on file 11th. There is another one. I don't know whether you want to abandon that one. It was filed on the 17th November.
That will be the motion to arrest judgment, my Lord.
It has to do with motion for bail.
That is also there, my Lord. I was hoping to
identify them so that I know the number of motions I'm taking.
Okay.
You have identified two.
Yes, my Lord. This was dated. That's the motion for bail. Dated the 17th day of November 2025. Sorry. Dated the 25th, is it? Yes, 17th day of November, and filed on the 17th day of November, my Lord. Those are the three motions I wish to move.
Yes, counsel to the prosecution.
May please, Your Lordship, we filed a reply.
Are you ready for those?
Oh, I am ready to argue the applications. Thank you, my Lord.
Thank you.
Thank you, sir.
In interest of justice and in order to save judicial time, the three motions as identified by defendants are hereby consolidated for hearing. Defendants, can you proceed? Move those three motions.
Thank you, my Lord. I shall move the motion on bail last. Let me move the most critical ones first. Here is not enough to contain my paperwork, so it's a bit muddled up,
Can I
my
tell
Lord.
you one of your legal consultants to move to you?
Please, my Lord.
Mr. Ejimako, can you move to the defendant you consult for?
I am most grateful, my Lord. My Lord, I am the defendant, applicant, appearing for myself in person, and I most respectfully adopt as my argument in support of this very motion on notice the following processes which I personally filed and served on the prosecution. An order, this motion, my Lord, was filed on the 12th day of November, praying this honorable court for the following reliefs. An order referring the substantial constitutional questions raised in this trial to the Court of Appeal pursuant to Section 2952 of the Constitution of the Federal Republic of Nigeria, and an order staying further proceedings pending the determination of those referred questions. The supporting affidavit was deposed to by my younger brother, Prince Emmanuel Kanu, together with all annexures. My Lord, my written address filed in support of the motion, wherein I adopted and argued the three jurisdictional issues submitted to your Lordship for your determination. There was also a further and better affidavit and my reply on points of law filed in answer to the respondent's counter affidavit and written address. My Lord, I respectfully urge your Lordship to deem all these processes as argued and to grant the reliefs exactly as set out on the motion paper. And in a brief overview of what is contained in my motion, my Lord, my contention is very simple. That ab initio, this court lacks jurisdiction to try me, that this very court is a material defiance of an appellate court judgment, the Supreme Court, with specific regards to count 7, which does not exist in the laws of this very country, and which the Supreme Court mandated this very court to amend. That hasn't happened. The presence of count 7 on this charge sheet, my Lord, nullifies this entire proceedings completely and totally, because count 7, my Lord, does not exist in the laws of this very country. When I reply on points of law, I will make specific references to the ratio that came down from the Supreme Court, where my Lord Lawal Garba explicitly stated that count 7 should be changed. That hasn't been done, my Lord, and this court is in contempt of the Supreme Court binding order. My Lord, the entire argument of the respondent, I'm sorry to say, collapses on just one single point, not many, just one. The Supreme Court's pronouncement on the status of the written law is immovable. It is enshrined in the Constitution of this very country unless a law is written. Unless it is written, defining that very offense, no trial, no conviction can ever take place. And it is my submission, my Lord, that this very morning, as we stand in this very hallowed chamber, count 7 does not exist. And not only the repealed laws that will come later, count 7, my Lord, destroys this entire trial, because Supreme Court gave an explicit order which wasn't adhered to.
The consultant, you have to go to the defendant to tell him the procedure here. We have the practice of front-loading. I think he has filed his written addresses in support of all this motion. So it's not to repeat what he has stated in his written addresses, but to state the relief he seeks for, and just use a minute each in respect of each motion for adoption.
Okay. But it wasn't, they didn't reply to it. Yes. Okay. I am most grateful, my Lord. I am, without flogging a dead horse, I am asking this very honorable court, my Lord, to please kindly grant my prayers as contained in the motion for reference to the appeal court. And may I also identify the affidavit in support. It is only a 6-paragraph affidavit, my Lord, deposed to by my younger brother, Prince Emmanuel Kanu, also dated the 12th day of November 2025. There is an accompanying affidavit of urgency, which was deposed to by my humble self, also filed on the 12th day of November 2025, and also a written address. My Lord, in support of the motion on notice, praying for the orders I had earlier outlined, that too was dated on the 12th day of November. My Lord, may I most graciously ask my Lord to grant these prayers. Thank you very much.
What about the other two motions?
I should move them at the same time?
Yes.
Thank you.
I've made an order consolidating the hearing of the three motions.
Okay. The next one, my Lord, is an application, a notice of my commitment to file a final written address, which was dated the 11th day of November and filed on the same 11th day of November. It is accompanied, my Lord, by grounds upon which this very application is predicated, and the grounds are 4 in number, my Lord, and I went on to elucidate the body of objection and then the constitutional foundation and jurisdictional limits of this very court.
You will have the grounds stated?
Yes, my Lord, you may. Ground number 1, my Lord, states here, the defendant, having called evidence through cross-examination of all the complainant's witnesses, has given evidence and entitled to the summation of those points through a final written address. So I have actually entered my defense, my Lord. What I did not do is to call a witness, because the evidence tendered by the prosecution were surgically demolished. The right to ground 2, my Lord, the right to final address is a fundamental constitutional right integral to fair hearing under Section 36, Sub 1 of the 1999 Constitution, and no court has jurisdiction to unilaterally order its waiver without the express, informed, and voluntary consent of the right holder, which is myself. The third ground, any order directing or implying a waiver or final address constitutes a breach of fair hearing, my Lord, which goes to the root of the court's jurisdiction and renders the entire proceedings a nullity. The court, ground number 4, the court lacks jurisdiction to extinguish or dispense with mandatory procedural stage of criminal adjudication, such as a final written address, as this would amount to an unlawful assumption of power beyond the limits prescribed by the Constitution and extant laws. And ground number 4, for reference purposes, my Lord, Section 36(1) of the 1999 Constitution, which I'm sure the court has taken judicial notice of. Those are my grounds, my Lord, in respect of the notice, seeking this court's discretion to allow me to file my final written address. Having entered my defense, I move that this very notice be adopted, my Lord, in its entirety. The third and the very last one is the issue of bail, my Lord, the issue of bail. This was dated the 17th day of November 2025 and filed on the 17th day of November 2025.